Thank you, Mr. Speaker. I'd like to start my contribution by quoting some thoughtful comments made by leading legal experts and relevant stakeholders. Law Commissioner and former Chief Statutory Draftsman George Tanner QC says that the bill would fail to meet the test of responsible regulatory management, even based on the bill's own principles. Auckland University's Dean of Law Professor Paul Richworth says it could clog up the court and draw officials into legal battles. New Zealand Herald commentator Brian Fallow says the principles are abstract, constitutionally unorthodox, and substantively unsound. Even the Treasury's evaluation of the bill does not support it. According to the Treasury, there is no clear advantage over other available methods in using legislation to promote regulatory quality other than legislation being necessary to provide for the new role of courts. Further, Treasury rates the potential to induce change in behavior as low, the risk of unintended outcomes as high, and the potential to reduce costs as very limited. No wonder Alex Pink, Policy and Research Manager at Maxine Institute, described the bill as a wolf in sheep's clothing. Labour opposes this bill. I have 5 main reasons to oppose this bill. The first one is this bill changes the role of Parliament and courts and requires a certification by ministers and chief executives. This means the chief executives, in effect, certify whether they would enact a particular law. The certification regime therefore virtually put chief executives in the position to politicize themselves and arm them to veto government policy in a way that is inconsistent with our constitutional arrangements. Secondly, the bill would be applied to new laws, but after existing for 10 years. It can apply to the existing regulation as well. This could empower the courts to reinterpret provisions in other laws to make them consistent with the principles prescribed in this bill, thus changing the original intention of Parliament when a law was enacted. Thirdly, much of the principles are redundant as they are provided for in other legislation, for instance, the imposition of taxes except by or under an act, which is already the case. Therefore, the principles contained in this bill are ideological, vague, and create legal uncertainty. And fourthly, not only the legal uncertainty, this bill will create extra compliance costs for public entities, which will now face more onerous annual reporting requirements. And finally, this bill aims to fix an exaggerated problem. The regulatory impact statement states that while New Zealand lacks its own indicators of legislative quality, the best international surveys available suggest that New Zealand does not have fundamental problems with legislative quality when compared with other OECD countries. Looking at the content, the bill has 3 key components, namely 1, certification, 2, judicial declarations of incompatibility, and 3, interpretation to ensure legislation conforms to those principles. The bill establishes a so-called benchmark for good regulation through a set of 7 regulatory principles. All regulation, including primary, secondary, and tertiary legislation, excluding instruments made by local government, should comply with these principles. The bill aims to provide transparency by requiring decision makers to certify whether regulation they are proposing is compatible with the principles. And finally, the bill provides a check on the certification process by allowing the courts to provide declarations of incompatibility where they believe the principles have been breached. However, Mr. Speaker, this power is declaratory only with no direct ability to overturn or amend the offending legislation which likely consistent with the separation of powers doctrine. I have three further concerns. The first one is that the Regulatory Responsibility Task Force failed to justify why this bill is even necessary. There is very little evidence showing why a vigorous or intensive approach is required as opposed to the other options suggested by the Commerce Committee. And based on the calls from both of the National and ACT MPs, there is no convincing argument as to why legislation is required to ensure better legislation. The second one is the bill uses open, textured language that will lead to uncertainty of meaning. According to George Turner QC, it attempts to define good law-making by reference to a set of simple principles, and in doing so, it obscures the complexities inherent in them and creates the same lack of clarity and uncertainty that it seeks to prevent. My third concern is with regard to the role of the judiciary. Sir Geoffrey Palmer pointed out in a recent article that neither the judges nor the legal profession are proficient in policy analysis of the type that leads to regulatory legislative proposals. In this respect, the bill actually confers on the judiciary a new role for which they are not equipped. Our already overburdened court system should not be further encumbered with overseeing regulatory legislation. Mr. Speaker, I had the pleasure of reading a well-researched article authored by a senior lecturer at the Faculty of Law of the University of Auckland. Richard Ekins argued that this bill is unconstitutional and authorizes courts to review the detail of policy, illegitimately constraining Parliament and calling into question the validity of much secondary legislation. Of particular interest is Clause 7, Sub 1, Sub B, which states that legislation should not diminish a person's liberty, personal security, freedom of choice or action, or right to own, use and dispose of property, except as is necessary to provide for or protect any such liberty, freedom or right of another person. A substantial number of legislative acts do and actually diminish a person's liberty or freedom of choice. Mr. Ekins cited an act entitled the Bake Shop Act 1896, New York, that prohibits any person from employing another to work in a bakery for more than 10 hours per day or 60 hours per week. That act would depart from paragraph B of this bill, for it restricts the freedom of contract of employer and employee and is not necessary to protect any existing liberty or freedom of the employee or any other person. The legislators might attempt to justify the act by reference to the health of the worker or the need to protect him or her from economic exploitation. It would be open to the courts to consider this rationale and to decide that the legislation is an unjustifiable limit on liberty. The article went on to say that the bill also states in paragraph C that legislation should not take or impair property unless this is necessary in the public interest and full compensation is paid. Such compensation to be paid if practicable by those who benefit from the taking. Mr. Ekins argues that the principle conflates takings and impairment. The effect is that limiting how one uses property attracts full compensation. The point of the principle is to make it very expensive to limit how property owners may act. For any property owner who suffers loss from regulatory change is entitled to be made whole. Thus, I quote, if Parliament wishes
Sorry to interrupt the honourable member.
dangerous
His
weapons,
time has
it
expired.
must buy.
Call Melissa Lee.
Thank you.